How's everybody doing? A couple of disclaimers before I get started. One, I've given permission to record this for the Young Professionals group, and I want to say this on the record. I don't speak to your basic standard of care. I basically speak to a higher standard of care because it's my impression that the people that come to these things would rather work at a higher level for the benefit of their client than just sort of scraping the bottom. So for those plaintiffs' lawyers that might hear this talk, this isn't the standard of care. This is higher. Number two, I just got back from vacation and I kind of hurt myself a little bit. Forgot to look at my birth certificate and went bike riding with my son and took a little tumble. So I can't hear too good because it was a pretty good fall. Actually laid me up for 2 weeks. So I know. I went diving the day before and saw 17 hammerhead sharks. Nothing. I go taking out a motor scooter 49cc and blow it up. It's amazing. Amazing. So I can't hear too good. So if you have questions, which I encourage you. I hope that was not. I hope that was the mic. Whoa, it's worse than I thought. I encourage questions, but please speak slowly. And you have to do that anyway with me, as you know. But speak up a little bit because I'm not hearing too good. Let me tell you what I got cooking here today. I've been gone a month, so I'm a little bit out of the loop. So let me tell you what I have today, and then if there's something I haven't mentioned, we'll make a good answer up and we'll move forward. Number one, they sent me yesterday, and I looked at them this morning, the new forms for November. And they're really some great modifications to the current forms I want to bring to your attention. I'm going to do it really quickly because in the later part of the year we'll do another one of these and I'll actually go over the final version. These are the comment versions, but at least you'll know what the forms are. I'm going to nag the ladies just a little bit because of a case that we handled recently and something that happened here in Temecula that Connie brought to our attention regarding some safety issues. Just be a minute, put up with me. You have to anyway. I'm going to go over the MLS rule changes that were just adopted because the fines are going to go up to $2,500 for some of these things. You'll want to know what they are. And so we're going to talk about that just a little bit. I was talking to one of the directors the other day, and she pointed out that there are, and I've seen that myself in our practice, a lot of service men and women who live here. And so I want to just give you a little taste of the Soldiers and Sailors Relief Act, which does things for the active military people regarding lease terminations, regarding non-payment of rent, regarding foreclosures that you may want to know about. It will be one of the two topics of the next newsletter. Okay, we're going to go into a little more depth on it because while it may not affect everybody, certainly it's something all of us should know. So we're going to talk about that a little bit. I got a whole bunch of cases we may or may not get to. If we don't get to them, they'll be in the newsletter. And then I want to talk to you guys about fraud. You're number 4. Right on. You are 4th in the nation in fraud in real estate. 5 of the top 10 and 6 of the top 7 are in California. So you are surrounded by bad guys. And so I want to talk to you about some things that Gene and I have been working on, and Howard and some of the other directors, and kind of bring you up to speed on that. And then, and I want to tell you, there's been a change to the MARS rules, the Mortgage Assistance Relief Act, but it's been a change, not a complete rewrite. And so I want to make sure you guys understand what you're supposed to do for short sale disclosures relative to your services. So I'm going to touch on that too. A lot of stuff to cover in an hour and a half, so I ought to get started, huh? Let me just tell you briefly what the forms are going to be and just a couple of highlights of them. First of all, there's going to be 3 new forms. One is going to be a form where there are going to be multiple brokers on one side or the other so that it can be acknowledged that it's not just one broker handling a transaction, it's multiple brokers. And so there's actually going to be just a little one-page form for you guys to disclose your existence, make sure you get your commissions covered, be able to do that kind of thing. There's going to be a form, as you know, you have electronic signature capability right now because of your realtor membership. And there's going to be a form that will allow you to have a signature for your file that will verify the existence of signature, electronic signatures, and how you're to do that. And again, I'll go over all this, and remember, these are the November forms, so we're a little early, but just to bring it up to date. There's going to be a new water heater statement of compliance, and that one hasn't even been put out in a draft yet, so I haven't even seen it. It's supposed to come out on the 9th, and they told us they would send it to us. They're going to modify, they're modifying the addendum that you guys use. That's the form where you can frankly practice law without a license. It's got all the lines. Really be careful about using that form, but they're going to use, they're adding the residential listing agreement as one of the documents that this form can be attached to. And I haven't seen it yet, so I don't know what it looks like, but there's a form that, for those of you that are really into risk management, it's a great little form. It's the buyer material issues form. I go in and I tell you, my primary issue is you can't have any cats ever lived in the house because I'll look like Quasimodo. You write that down, I sign it. Those kinds of things where a buyer has told you what their material issues are, and they're going to modify that form to bring it a little more up to date because of some changes in the law. They're going to be modifying all 3 of the buyer-broker representation forms. And they're going to be making a couple of minor modifications to it. So just be aware of that. Again, I'm going to go into more detail on those when they come out. For those of you that do commercial, they're going to be modifying the commercial lease agreement and just adding a couple of sentences dealing with the landlord's right to deal with partial or total destruction and how that's going to work. Sometimes, as you know, I had a fire, lost my entire building. If I had been renting it, obviously I would want rent abatement. But sometimes the property isn't totally destroyed and there is a partial use, and they've modified that paragraph. They've changed the language in the buyer-broker representation form to make it a little clearer, I believe, what your duties are and what your limitations are. So for those of you that use that form, and I hope that's all of you, I would keep an eye out for those changes when they come down. There's going to be a very minor change to the notice of changes in terms of tenancy for those of you who do that property management. There is a fairly significant rewrite of a new form that just came out in April, which is the denial of rental application for credit reason form. And they made it nice. They said, they put a dear applicant a thing in here that basically tells them how you regret to basically not let them have a home to live in. And then there's some more expanded information on how they can get a hold of the consumer agencies that have given you the information that led to the denial of the application. There is a really good change to the market conditions advisory form. It's a whole sentence dealing with appraisal contingencies. The fact that if the appraisal comes in and you've already removed your appraisal, you may lose your deposit. The fact is they may not lend, they may not give you as much as you need, that whole problem that you guys have. And this is simply something that you can put in writing and give to them that says, look, you remove that appraisal contingency, and then the appraisal comes back, or a review appraisal comes back, and you don't get your loan. It's not my fault, and you're at the deposit, because that comes up once in a while, as you know. They're going to change the residential listing agreement. This is one thing I never understood why they didn't do this in the first place, but they're doing it, and so yay. A lot of you don't use disclosure forms that are available to you when you take a listing, and this form is going to clarify what your duty is and what your duty's not. And it's basically a whole new paragraph on limitations of duties. You already have, it's already part of the law, but it's going to be put in the residential listing agreement itself. Okay? And these forms usually come out, Connie, November, usually like the second or third week in November, right before NAR, I think, is when it's going to come out. They're going to change the seller advisory, again, to talk about the general disclosure duty. Look, here's the deal. You guys love the as-is clause. I have no idea why, but you do. But as-is doesn't mean you don't have to disclose things. And so in the seller advisory, it's going to specifically tell the sellers, look, even though you've told me to list this property as is, that does not relieve you of your obligation to disclose known material facts and defects and items that would affect the transaction itself. So that form is going to be modified. It's going to be part of paragraph 2A, and that will come out again in November. The statewide buyer and seller advisory is being modified, and I can't recall what the change. Oh, just a little minor change dealing with the common interest development changes that are being made to that form. There is a change to the seller property questionnaire that says, and this is really a kind of a good, smart change, is that if you, seller, don't understand how to answer a question, go see a lawyer or someone else, because I'm not qualified to tell you what you should say, and I certainly am not allowed to tell you what to say. And I cannot fill this form out for you. So that's going to be on the SPQ form. It's going to be part of the notes to seller at the very, very beginning. And they're also going to add some sections regarding whether or not people are leasing solar systems, water softeners, and if there's an alternative septic system on the property. I have no idea what an alternative septic system is, but it sounds gross. But anyway, that's going to be part of the new form. There's going to be some fairly significant changes to this short sale advisory. I'm hoping you guys really have read that form. That form is an excellent form because it really goes into a lot of detail for both the buyers and the sellers on the specifics of a short sale. And they're going to be changing it to take into account the law that I'm going to talk about later, which is the new amendment to 580E, which says basically there's no deficiency once the lender accepts a short sale. And what it does, though, is it warns the parties that if there is fraud, waste, or some other restrictions, then that exemption will not apply. And it also recommends to your clients in writing that they get written confirmation from the lender that there's not going to be any deficiency. So, and it also warns them, one of the issues that seems to come up a lot, at least in my practice, probably because I'm on the dark side of the force, is homeowner association liens and other types of liens that survive everything except foreclosures. And so even, well, frankly, actually homeowner association liens survive foreclosures on the personal side because it's considered a personal obligation. So even though the property's gone, still a personal obligation, and a lot of associations are taking people to small claims court. And so there's a warning they've added to that particular clause indicating that that's the case. And they've also talked about the fact that short sale negotiators are not necessarily representing one party or another, and so there's some language in here regarding short sale negotiation. This is really, if you do nothing else, this is the form we're going to spend some time on when it actually comes out. They're going to modify the real estate disclosure form because there's been some changes, as you know, to the water conserving plumbing fixtures. There's a code change that requires everyone who built a house before 1994 to put certain types of water flow fixtures, anything that they can do to add to the cost of a sale. So, Gino, get on that for us, would you please? So, yeah, well, they'll get to it eventually. They'll figure out how to slow the market down because it's probably too fast for them. All right. Here's my factual situation. And this is a true case. And Connie brought another issue to our attention while I was on vacation. And so here's the issue. There's been an enormous spike in assaults on real estate agents, particularly female real estate agents, particularly female real estate agents who are alone. So we wrote an article that I assume has been posted in the association's website. Anything we've written or that I allude to that you don't have, you can go to the association's website. If you can't find it, give me your card. We have a magic box that's in this little box up here, and my secretary will email the information to you. But we wrote an article on that I really would like you to see, those of you that are broker managers, use in your training, particularly for the, again, for the females. Let me tell you a case that actually happened in my office. Property is not in a particularly great area. The agency brokerage decided to have an open house. The broker decided that he would make 2 agents sit the open house so that they would be able to keep an eye on each other and they limited the amount of hours that the open house would be available, and they closed it down at a particular time. The primary listing agent, a female, left the premises and came back a short time later just to make sure everything was okay. Again, not the best area in the world. And she saw a car in the driveway. And just one car, and it wasn't one that was recognized, didn't have any materials on the side like you guys like to do. And she pulled up behind it and blocked its ability to leave. She then went to the front door, and someone had put a chain on the front door. Okay? Are we getting the idea that maybe she shouldn't have gone any further? Okay? I'm going to give you an advance warning. She didn't get injured. I just want to tell you, obviously what could have happened to this lady would have been catastrophic. So she went into the back, and she had a regular house key. She opened the door, and she said, "Who's here?" And yeah, that's why I'm only 28 years old and look like this. A prostitute came out of the bedroom. I'm not going to go into how come we know it was a prostitute, but you can fill in the blanks. You guys are all creative geniuses when it comes to that kind of thing. So, prostitute comes out of the bedroom, and she's a little bit hammered, and basically tells the agent, "You got to talk to the guy in the bedroom," and she screams out, "Get out here right now," which of course is a wonderful thing to say, not knowing who you're talking to. Well, it's another agent from another office. And so he starts screaming at her pretty violently, calling her all kinds of names. He goes out to leave. Their car's blocked. The car's blocking. He's screaming and yelling at her. Again, thank God it was another agent and not something significantly worse. She calls the police. The police finally get there, put him under arrest, and take him away. And he is immediately, turns out that he works for one of the brokerages that the director of that particular board is on, fired the next day, reported to the Department of Real Estate. But again, I point out, you gotta keep your eyes wide open. Okay, again, this is not the best of times. This is still Temecula. Obviously we have no crime in Temecula or Murrieta. Stonewood certainly not being one of them. And so, with all the fraud that's going on here, with all the stuff that's going on out here, read the article, think about what you want to do to protect yourself. We've made some recommendations. We didn't make them up, but be careful, please. Nothing happened to this guy. By the way, she checked the lockbox access. Turned out that he'd been in that property in the evening 4 or 5 times. Clearly a very diligent agent. So, there's an article that Connie asked us to write. It's called the Safety News Flash. It's one little page with some suggestions of things you might do. Obviously, it's not mutually exclusive to whatever else you may be wanting to do. And there are toolkits on both the NAR and the CAR site that can go into greater detail. But protect yourselves, please. This isn't worth dying or getting seriously injured. And you're more valuable than that. So, please be careful. Any questions about that? Or the DRA, by the way, has started an accusation, and I suspect that Mr. Whatever his name was. I have a name for him in the office, but we won't go there. So we're probably not going to see him ever again. How stupid is this guy to not apologize and try to make nice? I mean, that's a whole other issue. Okay, MLS. Most of you have heard by now that the Southern California Multiple Listing Service no longer exists. As I understand it, that the merger has taken place, and CRMLS now has all of the all the SoCal associations, which have added significantly to your numbers, and you are now the largest multiple listing service in the United States. That may be good, that may be bad. We can have a nice debate one day, certainly not on the record. However, Carrot still controls the rules, and so I want to point out a couple of things that they talked about. First of all, we wrote an article back in May about all the rule changes that went into effect on July 1st, so I would urge you to bring that back up and take a look at that. A couple of little things. We're having a lot of issues on short sale offers. You've got to make sure that it's crystal clear. It's one of the few exceptions to the rule that says you cannot make conditional offers of compensation. Most of you know that, hopefully all of you by now. However, when you put that you're going to, that it's subject to lender approval, you need to be very, very clear how the reduction that you're going to be willing to take is going to be split. And you want to make sure that that's objectively crystal clear. There was an article that was in Inman last week that talked about some cases. I haven't seen one yet, but that talked about some cases where the use of the phrase 50-50 split is really not sufficient. So think it through and make sure that it's crystal clear what the split's going to be, so that you don't end up in an arbitration over how much you do or don't owe to another agent. Lockboxes. Children. You guys are so cool. Apparently there's devices other than lockboxes that will allow you access to a property. I have no idea what they're called, but I've been talking to Jenna. And so what people are doing is they're putting these on, saying, well, but it's not a lockbox, and so therefore I don't have to share the information, and they've changed the rule and said, oh, but you do. Okay? So any electronic device that allows access to a property must be shared with everyone else, so that if you're going to put a listing in the MLS, which primary purpose is to cooperate with other brokers, you give them access to property. And now you've got a jurisdictional area that goes all the way from the valley to here. This is the southernmost today. I'm going to guess Sandy Core will participate sooner than later. All the way up to Palos Verdes Estates, and you have somewhere around 70,000 realtors in your multiple listing service plus carriers, which takes into account Beverly Hills, Los Angeles, and that area. So everybody gets access, okay? And you got to put a key in the lockbox, okay? And it's going to cost you $2,500 if you don't, okay? So Jenna participated with us in a conference call recently, and is fully aware of her jurisdictional rights, and you certainly don't want to get a letter from her, so cooperate. And take a look at some of the new rules. There's going to be some changes to a couple of the rules, but they're going to be fairly minor. But the other issue that I want to clear up is, and it hasn't happened in this board, maybe it has, I'm not aware of it, but in one of the other boards that I represent, there's been a huge influx of auction house listings. And one of the things that the auction houses were claiming is that the date and time of the sale should go in public remarks. In fact, there's the call right now. Should go into public remarks, because it is something that agents don't keep up on, and therefore, since it's a one-time deal, they should be allowed to make that announcement. And they've got support from that, because there's a multiple listing service up in Northern California run by a gentleman by the name of Harrison, which is one of the, I think is now the second largest MLS in California, that actually allows that practice to take place. And so the question, and of course, a lot of people didn't understand, well, if they can put the date and time of their auction sale, then why can't I put the date and time of my open house? Well, for one reason, they're not the same thing, but it was a good question. And so it's now been clarified that that information will not be allowed in the public remarks, that they have to put it in the agent remarks, and you guys are going to have to work it out with each other as to how you keep your clients abreast of whether there's an... This particular company's business model was that what they said is date of the open house, or date of the auction was this date, call your agent for details, and then they have all the information available to the agents in the closed section. And so that still wasn't going to be okay, but according to the MLS. So that's now carrots wide, and that goes into effect immediately. Status changes. 50% of all violations across the board are because of status changes. So it's really simple, and let me just give you sort of the thumbnail sketch of how to avoid a $2,500 fine. Number one, if there's a status change from active to backup or pending, or you withdraw, or you expire, or it's 2 business days. 2 business days. If you remember 2 business days, pretty much any information that needs to be changed in 2 business days. Up the price, lower the price, sell the property, put it in escrow, close escrow. Everything that needs to be reported in 2 business days, which includes status changes. Now, if 50% of the thousands of violations that are going on are because people aren't doing that, that doesn't make any sense to me. And as I teach these, Jenna teaches it here, but I teach it in some other places, and so I get to talk to you guys. And it's clear to me that the reason you don't change it, well, A, because you're lazy, not you guys certainly, but this other board, and B, because people don't understand the difference between backup and pending. Okay? Backup is backup. Backup means that your seller has still told you to accept offers as backups, and that's where you put it. If it's subject to some third-party approval, it goes into backup. If there is no ability, the seller has said, do not bring me any more. Remember, at the bank, the seller has said, do not bring me any more offers. It goes into pending. Okay? And so that's it. That's everything you need to know about that issue. The rule is written out. There's 5 or 6 categories of statuses. I would urge you to read that rule again, and if you have any questions, then Jenna knows that stuff backwards and forwards. I think I'm pretty good at it. You can send an email to one of us, and we'll be happy to make up a good answer for you. The bottom line is that I would talk to Jenna, because Jenna doesn't have to get you. Jenna is out to help you, and she'll answer your question. And if she's wrong, at least you're not going to get $2,500 fine. I think. It'd be kind of rude. So do that, because again, 50%. Oh, and by the way, one of the reasons I think that the statistics are skewered, and I don't know if it's happening here, but in a couple of the boards that I represent, people are basically reporting things over and over and over again. You know, now that you can click that button, you know, and so status, you know, hey, call and tell Gino, you know, let's complain against Gino because he's got a status change violation, and 15 people, you only need one violation to make it a violation. So again, if somebody has already filed a violation and you know that, then you don't need to do that because it's already been reported. And what that's doing is it's skewering the statistics and making it hard to analyze whether or not status change violations are as bad as we think they are. But because it's been reported to be so bad, they're going to hit the fine button a little bit higher. And then one last issue on MLS. The $2,500 fines, by the way, write these down if you have a pen. Rule 13.1, 13.2, 13.9, and 13.10. The fine is going to be $2,500 real fast. Okay, so take a look at those rules. I brought them. I can actually tell you which ones they are if you'd like. Would you like me to do that real quick? I'll just tell you real quickly. See, these are the MLS rules. They're not very long. They're a contract you now have with 78,000 other realtors and agents, so you really should take some time and read through it. Pretty good reading, fairly clear, most of it. All right, 13.1 is the lockbox rule. Okay? And so if you are putting a lockbox on the property, you need to put the lockbox that is used by your MLS, which is Super Lockbox. Okay? And that's going to cost you $2,500. If you lend your lockbox to other people, that's 13.2. 13.9 talks about failure to abide by the lockbox rule, and 13.10 has to also do with the right to limit access if you do it incorrectly. So basically what they're saying is that lockboxes have become a problem. We're going to nail you for $2,500 if you mess it up. So I know, Walter, you raised an interesting question about what happens if the lender has their own limited lockbox. In that situation, you need to be very, very cautious. It's going to be a question of proof. What happens sometimes, according to the people that do REO, is that the lender wants to put their own lockbox for access by their vendors and or staff, but is not necessarily creating a general access for others. And of course, now you get into that sort of slippery slope about, allowing people access, on a sort of a limited basis. And if that happens, it's going to end up costing that agent a pretty sizable chunk of change. Yes, sir.
Two questions. One.
Loudly.
Two questions.
Thank you.
One, some of the listings, for example, out in the Hemet area, use a central lock system.
Right. It's the only one.
I mean, yeah.
It's the only one.
Are they allowed? Is that
yeah, they carved that out because they joined SoCal, which is now CRMLS, late, and so they have a carve out. And you guys actually have a reciprocal agreement with them. so that the costs are the same. So there's check with Connie or with her people, and she'll tell you you're the only board that I'm aware of that has a reciprocal agreement with Hemet as to the central lot.
So they'll give us a card?
I don't know what they're going to do. I don't remember. I wrote the thing. I remember what it said. Okay. So, but there's an agreement, and Connie has it backwards and forwards. What's the other question?
There's companies out there that you've mentioned that are using combo lock boxes. And in some cases, one company is based out of India or something when you call. And it's very difficult to get those lockbox numbers. They're not saying you can't have them, you just can't get a hold of a person very often.
But a combo isn't a super lockbox. So still have to put, you could put more than one lockbox on a property.
No, but
but if you put a lockbox on the property, it has to be a super lockbox, and you can put however many you can fit on the door, as far as the other stuff. The point is that access has to be given to other members of the multiple listing service, because the primary purpose of the MLS is cooperation and sharing of data. There's no other reason for an MLS. If you weren't sharing data and cooperating in the offers of compensation, why do you need a multiple listing service in the first place? Seriously, it's not your profession. You're more than an MLS, I would hope. And so the MLS is the place where you put the information about the availability of property for the sale or lease, and how am I going to show my prospective buyer and thereby bring you an offer which would allow me to claim compensation if I can't get in and show the property because you're denying me access. Why? So that they'll have to go through you. And that's really why this all came about in the first place. Yes, ma'am?
So if it's to allow access to other agents, how come it's okay to offer $1 for compensation?
Because that's, oh gosh. I can't really answer that question in less than a half hour. Let me just use two words. The question is, how come we can offer $1? I don't know what that's got to do with the lockbox, but it's a great question. It's probably the most asked question. And the reason is because the multiple listing service is just that. It's a data bank. It's a data bank. I know it's got a lot of cool features, but it's a data bank at the end of the day. Offers of compensation are broker to broker, and the MLS, the board, cannot fix compensation. That is between you. Now, if I offer $1 under your rules, under the Code of Ethics and the rules, I'm supposed to tell my client that. And so we get into all sorts of subterranean ethics questions, don't we? But as to broker to broker, if I offer you $1, what are you going to say? No. Right? And then you're going to talk to your client, and it does put people in sort of a harm's way as far as their fiduciary obligations. But again, so you understand, the MLS is broker to broker. The MLS itself is simply a service that's provided by the board through its regional multiple listing service. And that's morphing as we speak. Into what? I don't know, but it's morphing. Yes, sir, and then young lady.
I have a super lockbox, and an agent takes the key.
Give me a second. Let me just pour a little thing of water here. I'm sorry?
I have a super lockbox.
No, but you might have noticed I'm dribbling a little bit. I had the fall caused an infection, and so I'm sort of starting to break through. So, yeah.
I have a super lockbox. I put a key in it. An agent takes the key, forgets to put it back, and therefore there's no key on the lockbox. Is there going to be a fine attached to that?
Probably not. Probably not. Like I said, Jen is not out to get you.
I understand that, but it's...
But how you prove that, of course, and how you track down the agent who took the key, that's a whole other issue.
You may not know.
Stuff happens. Look, these are rules that are meant to take care of hundreds of thousands of listings among 78,000 realtors, and there's 26 pages of rules. Is everything going to fit inside that? Of course not. And so periodically, you guys actually have to pick up the telephone and talk to each other and cooperate with each other, and hopefully you will do that. But if something comes up and you realize the key's gone, then Jen and know immediately and then start tracking it down, and hopefully you can get that fixed within a short period of time. You had a question?
Yes.
I don't know why it is, by the way, that the lockbox question at every single board is the primary question I get. Don't you guys want to know about the new laws regarding risk management? Go ahead, I'm sorry.
We just had a lockbox stolen. It was actually, they took a bolt cutter and cut the lockbox off, and we had to have, this was over this past weekend, and evidently have come quite a bit. And we had to call the police, have all the locks changed, we had to come staged, and now we're responsible and have to replace that lock.
Probably. Because the client's going to say you're the one that talked her into putting the lockbox on the property in the first place.
No,
I
I'm
would-
saying with the board. Yeah.
As far as the board's concerned, I don't know what the policy is. I'm sure there's some policy that basically says once you buy it, you own it, and it's your responsibility to replace it. So,
We're leasing.
huh?
We're leasing the lockbox.
You're leasing it. Well, if I leased a house and I destroyed it, would I not be responsible for that property? So, I mean, the fact is that, you know, I don't know if there's insurance you can buy or if it's even worth it, but these things are happening. And, you know, frankly, and I know Gino and Howard will probably agree with this, and Dana and the other people on the fraud task force, is that stuff is happening faster than we can deal with it. Every day, Gino just handed me a new thing. I have no idea what it is, but I got a feeling I'm not going to like it. You know, and so we met with the DA the other day, and he's assigned to us a prosecutor and 2 investigators just to deal with fraud in this area. And that's how, you know, so you got bad people out there, bad people. I don't know why. I think I have my theories, but you don't want to hear them. That's not just real estate. I mean, watch the news. You know, it's what's going on. Soldiers and Sailors Relief Act. We're going to write an article, so I'm just going to tell you real briefly that there is a law that was actually amended and updated in 2003 because of all the men and women going overseas. And of course, if I've rented a house or entered into a mortgage agreement and suddenly I go from whatever my salary was to whatever I'm making as a member of the armed forces, I'm going to have a materially difficult time making that payment. And the Congress, which is of course always generous with other people's money, has said, well, then we're going to create some areas of benefit, and I want to, so it does apply to leases. Okay, so if you've got and again, it's a lease that was entered into prior to active military service. It could be, it also can stay a foreclosure. One of my directors actually, we had a conversation about this the other day because she has a client who is having some problems, and we're going to take a look at whether this law will apply to that situation. I don't know that it will, but it might, because foreclosure can be affected because again, I'm making a lot less money if I qualified for a loan as a realtor and suddenly get called into active duty because I was in the reserves, and now I'm making, you know what you guys make, I'm making 1/10 of all that. And so it's really serious. And it also can require all installment contracts, including credit card companies, to reduce interest down to 6%. So again, the one thing that was emphasized when I reread the statute at the request of the director, because we're going to put it in the newsletter. If you're interested, you'll be able to get a summary of it. Is that it's a case-by-case analysis. Okay, there's not a lot of sort of overarching rules that you can look at, but what I want you to understand is that if you're representing someone who is in the military and is facing some kind of economic harm, then you need to be making sure that when they go talk to a lawyer or to a financial planner or whoever they're going to talk to, even a bankruptcy attorney, that they are aware that there are specific rights under the law. And those rights were expanded fairly significantly in 2003, which of course is a direct response to Iraq and Afghanistan. So there's a pretty good 6-page article on the CAR website called Service Members Civil Relief Act, if you want to look at that, or you can wait till next week and get the newsletter from us. Okay? But again, it does require active duty. So we're not talking about guys and gals that are in the reserves. This is people that are on active duty. Okay? A couple of new laws I want to bring to your attention. 3 to be 4, 5 to be specific. Okay? Small claims is going to $10,000 on January the 1st. Its current is $7,500. Why does that affect real estate? Well, because most of the disputes regarding deposits are going to be covered by now by the small claims court. Not necessarily the best place to go because judges seem to not necessarily have a good handle on what is and what is not a recoverable deposit, when the seller's entitled, when the buyer's entitled, but that's really frankly, not your problem, because it's exempt from the mediation clause. If a transaction is qualified for small claims, you don't have to mediate and you don't have to arbitrate, even if the arbitration clause was initial. It is exempt in your RPA contract. Okay? And it's it used to be paragraph 17, it's now I think 23 or 24, something like that in the new RPA. So that paragraph basically says that you can go to small claims court. So if I think that I'm entitled to my deposit back and the seller won't release it, go to small claims court if it's less than $10,000. Starting on January the 1st, $7,500 today. Okay? So just be aware of that. The entire enforcement of RESPA is moving into a new department that is just being born. Isn't it great? I feel so much better knowing that we have a whole new federal department that's going to stay small and become efficient and do exactly what it was originally intended to do, like all the others. Anyway, RESPA will no longer be in the HUD, and they are hiring an enforcement office. You can tell I'm pretty conservative, so let's get that out of the way. But RESPA is now going to be enforced by this new Consumer Protection Department, along with all the bank stuff. And I went to Chicago not too long ago to an NAR lawyer meeting, and they had a guy in from the new department, and he said one of the things they're going to be really carefully monitoring are referral fees for home warranty contracts. So if you accept anything of value from a home warranty company, you need to be aware as we flesh out the new regulations, whatever they will be, and make sure you keep an eye on that so that you can do it correctly on either side of the situation. There's going to be a change. I told you about already to the TDS. So in November, you want to start using the new TDS. It's going to be on not WinForm. What's it called now? Zippy?
Zippy.
Yeah. So it's going to be on Zippy, and you'll get it automatically. But if you're one of those people that buys hard copies, throw them away after November, okay, because it won't be the accurate TDS. Now, two big changes to the law. One, we've already written an article, and it's back there in my blatantly commercial center, where I put my newsletter, our brochure, and all the other stuff that says what great lawyers we are. But one of the attorneys in the office wrote an article on the new statute. We talked about this the last time, but I'm not sure how many of you were here the last time, so let's do it again. California has a Civil Code of Procedure Statute 580, and it deals with things called deficiencies. Deficiencies are where somebody takes back security, sells it, doesn't get enough to cover the debt. I now have a deficiency. Very common, of course, in automobile situations where people get their cars repossessed. California has some very specific real estate anti-deficiency legislation, and it is found in Civil Code of Procedure Section 580, B, D, and E primarily. B has been around for a long time. That's the statute that says if it's a purchase money loan on a residential property, 1 to 4, whether it's a first or a second, the only remedy that the lender has is the security itself. In other words, in California, foreclosure. Okay? Once they foreclose, they're done. There is no further obligation. If the seller carried back paper as part of the purchase price, that's purchase money. Seller's wiped out on its security, and obviously its note becomes valueless because they can't sue on it. 580D says, no, there's two kinds of foreclosure in California. There's judicial and non-judicial. And what 580D says is that if a lender avails themselves of the non-judicial foreclosure, 90 days, wait, file a notice of sale, do an auction, take the property back, no court activity. If they do it that way, regardless of the type of loan, regardless of the type of property, it could be a commercial building, it could be vacant land, it doesn't matter. There is no deficiency. The only way you can get a deficiency in California is to sue judicially, and there is no jurisdiction to sue judicially on purchase money residential loans because of 580B. But now we've had this market for a couple of years, and of course we have this thing called short sales. And the banks took the position, well, we're not foreclosing. And therefore, this statute should apply, and we're entitled, if we're going to be willing to agree to a short sale, we're going to be entitled to reserve our rights and go after these people. And I've got tons of cases in our office that are basically collection cases where these banks are coming after people. So the legislature dealt with it. The legislature said, look, if it's a short sale on a residential property, then there can be no deficiency once the bank accepts that, but we're not going to make it applicable to second trust deeds and those kinds of things. And they just amended that statute effective July the 1st. So 580E, which went into effect on January the 1st, was amended effective July the 15th, and now basically says, if the lender accepts a short sale, you're done. There can be no reservation of rights on a first or the second, period. So bottom line is, if you can negotiate a short sale and they can get a little bit of money, that's all they get, they're done. Okay? And they basically, we were hoping it would be retroactive. It is not. But it is, I think, Gina, you said there were 7 bills. Those of you that pay your, what is it, $89, $49? What is that amount? The political action money? Know that you have now sponsored 7 bills, and 4 of them have already been signed into a law. The 5th is on the governor's desk, expected to be signed by Friday. I guess you're doing really good. And this was one of the bills you sponsored, and it's cleanup legislation. That article goes into great detail about how your consumers protected. But I want to make sure you understand something. Fraud exempts the transaction from the anti-deficiency restriction. Okay? And so when I talk to you about the loan flipping problems that we seem to be having, and all the other stuff that's going on out there right now, the false applications and all the other stuff, know that you're not going to get that protection. It only applies to good guys. Okay? And if your client decides that they're pretty angry at the bank and they're going to take the toilets, or they're going to take the fixtures, doesn't apply there either, because that's called waste. Okay? And think about that for a second. It makes perfect sense. The bank is basically saying, look, this is our restriction, we'll live with it, but wait a minute. You damaged the property purposefully. Therefore, we shouldn't be restricted because you lowered the value of that property by damaging it. Or you lied. There was money coming outside of escrow for this or that other thing. Or that velvet picture of the dogs playing poker was not worth $20,000 as personal property, and therefore you lied to us. And is that going on at all right now? Are we having any loan flipping fraud going on in the Inland Empire at all? I don't think so, right? But on the 1 or 2 transactions, I'm only kidding. It's rampant. Fannie Mae has just asked organized real estate for help in stemming the problem of loan flipping fraud. CoreLogic did a study, which I'm going to talk to you about in a minute, that says that they did a study that loans that flipped within a certain period of time were overwhelmingly fraud loans, or fraud transactions. CoreLogic, of course, is one of your data people. So, yes, sir.
On that new legislation, does that have any impact on the lender's ability to ask for a decision on a unsecured note?
Absolutely. It would be controversial. Basically, they're going to say the choice is simple: yes or no. Will you do a short sale? Yes or no. There's no other. Okay. Because that's what they were doing. They were asking for unsecured notes, which they would then sue on, and then we would have to set up the defense of no consideration for the note because of the purchase money nature of the transaction. Or they were asking for a reservation of rights, which you certainly aren't qualified to explain. I'm not even sure what they're talking about, because how do you reserve rights you don't have in the first place? And so you got into all that. This hopefully will solve a lot of that by eliminating that. And so, again, it's going to be in your seller advisory. One of the things your seller advisory says is send them to a CPA, send them to a lawyer, send them to a financial planner, let someone else make the call. And frankly, that's something we've been really busy at lately, because we have to look at that stuff. And what we're looking at is whether or not that's going to be, whether or not there's going to be any exposure there for that client. That's our job, not yours. What you need to do is basically, what CAR, if you looked at the new forms, the ones I mentioned at the beginning, what you're really seeing is they're really trying to push you away from the table and say, look, this isn't my job, this isn't my job. Because it really isn't your job, unless you actually went to law school. Yes, ma'am.
Real quick on the short sale, the new law, what's going to happen? You said it doesn't go back, it goes neutral.
I don't know yet. I haven't. We have a couple of cases in our office where, it's in that sort of mid-period. We just settled with Chase for $2,000 cost of defense on an $89,000 claim. So I got a feeling they're thinking that the courts are going to hold that because the lawsuit was filed after the statute. I don't know what the banks are thinking. They don't call me. It does at least give us another arsenal, or another weapon in the arsenal, I should say. So I'm not really sure how that's going to work. But unfortunately for me, good for your clients, we've seen a real curtailment since July of these kinds of issues. So that's a good thing, frankly. Yes, sir.
So the only thing, I know this is a new law, so no one knows what any of the answers are yet. So if you have a second and you release your lien, the debt's still owed.
Nope. Think about it. If I'm the second trustee holder,
Right.
and I accept,
No, you don't accept anything. The loan's in default, it's in foreclosure, people aren't paying on the first. You're so far underwater.
that's one of the things we're going to have to test. Because I read it to be liberal enough to say, you've lost your rights to go
No,
after
you
it.
don't have a lien anymore. There's no collateral.
And so the question is, can I sue on the note? That's going to be the
That's
issue.
my point.
Right. And I don't know the answer to that question, but I suspect the answer is you can't.
You shouldn't be able to. but-
There'll be a judge somewhere in California that'll decide, and ultimately it'll go to the 9 people in Sacramento, good and true. And hopefully, this is one time where hopefully they'll be liberal enough to decide on the side of the consumer. So we'll see. There's another statute that for those of you that are managing offices, there is a Senate bill that was sponsored again by CAR, brought up by Korea, who is in Orange County. Very pro-realtor fellow, from what I understand. I met him at a dinner. Seems like a really sharp guy. Even he's a Democrat, which kind of blew me away. I'm kidding. And it is a bill that will change. Right now, if you're the broker, even if you have a designated officer handling your office, you're still primarily responsible. And this will allow brokers and broker owners who have hired someone to manage that office who is a broker to basically take over a lot of the supervision responsibilities primarily, and will then, you have to provide a notice to the Department of Real Estate under the statute. Now, the governor hasn't signed it yet. We're going to take a gamble, and we're going to make it part 2 of the newsletter this month, because according to Gino, I know it's on his desk. If it was submitted when we think it was submitted, he has to sign it by this Friday, or it automatically becomes law. So if he doesn't sign it, actually, if he doesn't veto it, it becomes law effective immediately, or effective on January the 1st, and so it'll be a new law. So again, we'll put it in. I don't know if Connie does a special broker owner section, but it'll still be in the newsletter, and it'll go to every office. So MARS, the Mortgage Assistance Relief. First there was a statute we all got concerned about, then there was no statute, and now we have something back again. So here's the deal. We see a lot of advertisements that say basically, I'm a short sale expert. I'm not sure exactly what that means. But I'm a short sale expert, and I can keep you in your home, and I can do this, and I can do that, and all the claims that are made. Some of which are true, and some of which are maybe not true. What the MARS rule said is that if you sell, list, or advertise short sales, you were supposed to provide a disclosure at the bottom of your advertisement, which if you failed to do it would be in violation of federal law. And that disclosure basically said, I'm not a bank. If you stop making your payments, you're toast, and that kind of thing. And we sent you a newsletter, but it was really horrifically difficult for agents who take short sale listings and sell short sale properties to comply, because it was apparently very cumbersome and all of that. And NAR was able to get the Federal Trade Commission to back off, partially. What they've agreed to do is to stay the enforcement. They didn't redo the regs. They simply agreed to stay the enforcement. So, if you're a mortgage broker, still applicable to you. If you advertise that you are selling, that you are assisting in foreclosure relief, in other words, one of your primary functions is to provide foreclosure relief, and you're going to be sort of in that gray area. But I would think that you would be wanting to think about putting the disclosure on the bottom. And it's a simple 2-line disclosure that basically says that we're not banks, that if you do stop making your property, you run the risk of losing that property, and we can make no guarantees, blah, blah, blah. The language is preset. FTC wrote it, so you don't have to make it up. It's there. And there are 2 CAR forms for listing and for sales that came out not too long ago in May that you should also be using. But again, I want to kind of go over just a couple of the highlights just to make sure. Again, number 1 is that it is a forbearance of their rights to enforce. What they're really looking to see, with all due respect, is, are you behaving yourselves? If the organized real estate starts acting sideways, they're going to simply they're going to lift the stay, and they're going to enforce, and you're going to be right back to where you were a couple of weeks ago. So they're not saying that they're rewriting. Number 2, this is not an exemption to the statute. There are some exemptions to the statute. This is not one of them. This is a stay of the statute as it applies to people who list short sales as part of their business model. It does not, however, and it says this in the circular, it does not relieve you from conduct that is deceptive in nature. I have no idea what that means. I think it means don't lie. Okay? So if you say something that you can't back up, and the feds come a knocking, you got yourself a wee bit of a problem. And so again, it's part of your code of ethics anyway, so it should never be a problem, because it says in Article 2, don't misrepresent or exaggerate or conceal. Article 12 says be truthful in all your real estate communications, which of course includes advertising both on the internet and in print. And of course the MLS rules also have a truthfulness. So it shouldn't be a big leap to not be deceptive, but again, if there's deceptive practices, you're not going to be given a forgiveness. The purpose of the law is not to protect you, it's to protect the consumer. So if there's a tie, you lose. Okay? So again, be careful how you promote your business. I'm going to read you a little something here. Basic one, I'm going to read it because it's really long. But the thrust of it is that if you promote your business as a business that, as part of that business, will protect a client and help them avoid foreclosure, or you are solely a short sale negotiator, this stay does not apply to you. Okay? So for the vast majority of you, this stay will apply, and you don't have to use the disclosures. But if you're in that other group, you will have to do that. And the stay does not apply to mortgage brokers. Okay, because mortgage brokers aren't listing, they're making loans. Okay? So that's really some cool new laws I think that you should be aware of. And are there any questions about it? It's really complicated stuff. We're going to have to amend that article pretty soon. And CAR is coming out with a fairly lengthy 20-some-odd page thing that they're going to talk about. But you understand, and have I confused the heck out of you, or do we make it somewhat clear? It's good. Yay! I did it wrong. Okay. All right. I'm aware. Yes, sir.
You said a couple minutes ago that it's not using small
If you don't feel comfortable that the that the stay applies to you, and you want that extra bit of protection, then go ahead and put on the bottom of your advertisement the language that you'll find on your association's website that we wrote a couple of months back. Okay? And frankly, what's the harm? Unless you're trying to get people to not read that part. Which, if you're trying to get people to think that you're going to be able to keep them in their house without making payments for years and months, maybe you can do that once, maybe you can do that twice, but the reality is you aren't going to do that every time, even though you're not telling the truth. And so you'll get what you get. All right. Fraud. I have been practicing law for 33 years, since I was 2. I have never, and I would ask of this of those of you that are well seasoned, like me. I have personally never seen the level of fraud, misrepresentation, concealment, bad conduct I am seeing in the marketplace right now. And I'm particularly talking about real estate, generally, clearly, but particularly real estate. According to the FBI, San Jose is the worst in the country. San Francisco is second. Los Angeles, Long Beach, Santa Ana is third. Riverside, San Bernardino, Ontario is fourth. And San Diego, Carlsbad, and San Marcos is seventh. In the nation. In fraud. And so let me tell you a couple of things, and then we'll talk about some things that this board is doing to, and I got to tell you, you guys are my homies. This was my very first board in 1990. I started representing this board. And you've always been kind of at that cutting edge in a lot of different ways for a board that isn't really that big. Now you are. You've gotten kind of big. But one of the things that came out of the whole Stonewood fiasco, which was, for those of you that aren't familiar, was a $149 million fraud that primarily hit Murrieta and Temecula properties, was the need to figure out how we deal with fraud. So, a couple things. I'll start with what this board's doing. There's now a committee called the Fraud and Risk Management Committee, and it is a standing committee currently being chaired by your chairman, and how that'll work out over the years, they'll figure that out. I get to sit with them, and we've put together a pretty good program so that we're trying, and we're still working on it. Obviously, if it was perfect, I'd have it up on the PowerPoint right now. But the purpose of it is to give you a place to report fraud and to get questions, and we're going to start doing newsletters. I've already written an article that I'm going to pass by the committee that talks about, well, what happens to you if you don't report a fraud, if you participate in a fraud, and it's a cost of litigation and defense article. You ain't going to like it. Okay? But the purpose is to scare you, to make sure you understand that this is really serious stuff. The next thing that we've done is, because fraud isn't necessarily local, we're starting to connect with other boards. I talked to Gino's counterpart up in Orange County today, and Gina and I met with our new district attorney a couple weeks ago before I went on vacation, and he is absolutely on board. He wants to. What's interesting is the things we thought we were bringing to his attention that some of our people have brought to our attention, he already knew about, and they were already looking into. If you probably read in San Bernardino, a couple of guys just got convicted of a fraud, and so that's kind of what's going on at that level. At the state level, you have an incoming president of the California Association of Realtors by the name of LaFrancis Arnold, former member of the Denver Broncos, but I have personally forgiven him for that. And he's a really, really nice man. And he wants this to be a statewide situation. And so Gino's been invited to sit on a formation committee, which will be meeting in October at the CAR convention in San Jose. Nothing else to do, so Gino's going to go to a meeting. And the purpose is to link up all the DAs and all the associations and whoever else we can figure out to try and start putting a centralized handle on all this fraud. Because, frankly, it is so expensive to prosecute and so difficult to prove. I mean, think about it. Stonewood made $149 million allegedly. They can hire some really good lawyers. And they've gotten some convictions, but some of those guys are still being prosecuted, and it's very, very time-consuming and expensive. So the better is to get it on the front end. And one of the primary things, this is what we talked to the DA about, is how can we, all of us, create some kind of a early warning system for the elderly, people who don't speak English very well, people whose customs may be different than ours, and of course people that are just gullible. Okay? And that's pretty much the 4 categories we see. Remember, this is an association of realtors who represents the industry, you guys, and one of your jobs is to help protect private property rights and to keep the public informed. And so we're working that through. If you've got any ideas, I know that Connie would be appreciative of getting them. Don't inundate us with phone calls, just send us an idea, thought. If you see something that you think smells bad, I'm going to go over a couple of common scams right now. Let us know about them, because this is really affecting your marketplace. I mean, if you're 4th in the nation, and after number 7, there are no other California regions. So you're 5 of the top 7, and then you're not even in the top 20 after that. So it's highly concentrated. And if you've noticed the areas, it's concentrated in those areas where REOs and short sales also seem to be concentrated, which tells you what? It's a short sale REO situation. Gino?
Just, you can let them know that we've established an email address, fraud@srcar.org. If you run across things out there, please just send us an email, send us documentation if you can, whatever you've got. But just fraud@srcar.org.
I think you just sold
Thank you.
them. Seriously, guys, this is your problem. This isn't his problem or Connie's problem or mine. Because here's the deal. If you get sucked into one of these things, the bad guys are going to leave. You're going to still be here, and you're going to be a co-conspirator, you're going to be a perpetrator, and you're going to be a statistic, and you don't want that to happen. We're trying to develop a really good relationship with the DA so that obviously he understands that it's not realtors that are doing this, but it is realtors that are doing this. Some of the bad guys are out there and they're doing it. Okay, so I want to talk about 5 scams that seem to be fairly prevalent, some not necessarily. Obviously, there's 2 kinds of fraud. One is fraud for house, and the other is fraud for profit, sort of loosely defined in those 2 categories. Fraud for house is fairly typical, been around for a long time, probably never going to go away. That's why I really want the house, I'm going to rely on my credit application or something like that. That's going to have huge implications down the line because of short sales, because of the fraud restrictions and all that. But that's going to be narrowed to a specific individual or family, and it's basically so I can get a house so I can live in it. And then there's fraud for profit. And most of these are fraud for profit, and that's where I basically made stuff up. False. That's what Stoner was. It was basically false appraisals, false reports, false this, false that. Everything was falsified, and frankly, the banks didn't do a very good job of protecting themselves. So again, the schemes are number 1, the foreclosure rescue scam. There was a case that came out of Massachusetts, and that case basically said that if you don't have the original note, then you can't foreclose, and that case is not applicable in California. But we have all these companies that are out there telling people. We have one that was brought to our attention by 2 members of the committee. By the way, I'm not telling the names of the people on the committee for a purpose. It's like the grand jury. If the board decides later on, they'll tell you who they are, but I don't want them bothered. So blame me. I'll be the bullet guy. There's a company that's out there basically telling people, and again, not every trust is going to be a fraud, not every short sale is. So I want to make it clear. I'm talking about the bad guys, not everybody. So I want to make it absolutely clear. But in this particular case, you transfer my property into a trust, and we'll make sure that we get the property out of the foreclosure, and of course then they turn around and borrow money against the property, do all sorts of other things, and these poor people don't know what hit them. And we have about 700 properties like that we brought to the district attorney's attention. So most of these people are Hispanic, The people that, and then, the other thing that they do that we thought was pretty cool is they sign substitutions of trustees and requests for full reconveyance. And it seemed like one guy was working for 7 or 8 different banks using different. It's really, really. I mean, you think, like you guys go, oh my God, I didn't see the crack, and you're like freaking out that I committed fraud. These guys, man, they're blatant. They're just, they're just blatant. So they'll falsify documents. And so the foreclosure scam, and one of the warnings that NAR came up with, I think, is with foreclosure rescue program, borrowers are often advised to sign over title to their house, become renters, not contact the lender, and all that. And one of the reasons that we have a law in California that says that if you're in foreclosure, before any transfer of title is to become effective, you have to be given a 5-day cooling off period. That's the Home Equity Sales Act. So we have a statute, but by the time these people realize, and frankly, with all due respect, if you don't speak English, or you don't understand the customs, or you're really old, and I got to be careful about saying that because my daughter reminds me how really old I'm becoming. But if you're in that situation where you simply are trusting of someone else, that could be a problem. Loan documentation fraud, where documents are falsified. We just finished a trial, and the jury voted 12-0 to suppress all of the loan documents because our client didn't know what she was signing, and she signed documents that actually obligated her for $96,000 more than she actually got. And the way you do it is not that complicated. I mean, how many times have you guys sat down to buy something and gotten a stack of documents and just started signing stuff? And of course, with the robo stuff, and now with electronic signatures, it's even easier to do. So that's one type of fraud, where the document's just flat out fraud. Appraisal fraud, certainly. That's why CAR has put some warnings in some of the new forms coming out in November to tell people, look, there's going to be appraisals, and they may not be the way you want them, but some of them are frankly outright fraud. So again, this is the one where Freddie Mac and Fannie Mae are very concerned because obviously they're buying this paper in huge bulk, and they're relying upon the way the documentation is being put together. Illegal property flipping. I got something on Monday. I'm looking at it. I'm going to give my opinion. Talk to my committee. I've looked at it. I already have an opinion. Here's the deal. If I am an owner of a piece of property, and I'm not getting any money out of it, I just want out from under it, right? And a person comes along and offers me $150,000 to buy that property, and turns around and flips that property a couple of weeks after a short sale is approved for $200,000 and some odd $1,000. Is there a question in your mind as to how the bank approved the short sale at the 150 figure in the first place? Now, does that mean that every flip is a fraud? Absolutely not. I have clients that are making a nice, comfortable, relatively small per house living, buying properties in bulk, fixing them up, and then putting them back out on the market. But when a property sells within days for significantly more, you have to ask the question, how did that happen? And if somebody, I got to choose my words carefully, my wife tells me, she says, it's okay to have an unexpressed thought. But I'm going to say it anyway. I know things are tough for some of you out there, and I understand that the idea of earning 2 commissions on one transaction is very, very appealing. But is it, if that's the last transaction you ever get to do because VA Zellerback comes to say hello, that's really not necessarily going to be in your best interest. So, again, I can't tell you on a case-by-case basis whether this person or that person is committing a fraud, but I ask you to use your common sense. If the property is being flipped for significantly more, how did that happen? How did that happen? Because according to the ex-commissioner, Jeff Dobby, he and I did a thing last January at the convention, and I'll never forget what he said. If it's outside of escrow, it's outside the law. If money's being passed around the corner or being passed falsely, if it's on the table and the bank knows and they just want to get rid of the property and they're okay with how you're flipping it and blah, 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 I don't care, right? But if it's something where there is some kind of an illegal flip, and again, what CoreLogic did, and I would urge you to take a look at that article. CoreLogic did a study, and basically anything less than 100 and some odd days, they found an enormously high percentage of fraud. Okay? And that makes kind of perfect sense, because if the bank's being given an adequate appraisal. And then the other thing that goes along with this illegal flipping is where people are purposefully making the property less valuable by making repairable things wrong with the property, loosening banisters and all sorts of cool stuff. So that's number 4. And again, some key things to look at are rapid refinancing, where the seller has acquired title or title concurrent with transaction number 1, maybe never even closes transaction number 1, and then flips it into transaction number 2 within a relatively short period of time for a significantly higher price. And that's another Fannie Mae, that's on their watch list. And then all kinds of short sale scams where the borrower defaults on the mortgage, no workout discussions, immediate offers are made. And again, I'm not going to, that one I haven't seen too much of. But so again, fraud is huge, and the one that I want to talk to my committee about, because we have to kind of give you guys the best guess information we can and work it out as sort of a standard within Temecula, Murrieta, Menifee, and all that, is what do you look for? What's the checklist you're going to look for so that you can feel reasonably comfortable when working on a flipping situation? Because again, not all of them are bad. Now, how can you do that? But it seems to me that the red flags are pretty significant if it's going to flip while it's still in the name of the original seller. And we have a transaction right now where these people, again, they're blatant. They're telling the seller, you have to do this deal. No, you don't. No, you don't. Because there are other things you could have done for this seller. I have a case in my office right now where the issue in the case is the mortgage broker didn't tell the person who owned the property free and clear of the other alternatives that they had because they fell behind in their taxes. There's just all sorts of stuff going on out there. So be aware. All right, I've got about 10 minutes to go over about 24 cases. So I'm not going to do that today. If there's no questions, I'm going to go over a couple of sort of arcing things real quickly, because I promised to get you out of here at 1 o'clock. Yes, ma'am.
You said to go to a specific article about the flipping. What article is that?
We're going to write it. We haven't done it yet. Pardon me? Oh, the CoreLogic article. I'm sorry. I thought you were talking about the one I'm writing. Oops. It's called CoreLogic releases 2011 short sale research study. It's dated May 25th. It probably would be easier for me to send it to you or to post it on the association's website than for you to go looking for it, because the collective time it would take to do that. So why don't I give it to Connie, have her post it, you guys can take a look at it. Okay? I will opine that is not a violation of CoreLogic's copyright infringement. Okay, I did there's a group, and I can never remember the names of organizations, but it's essentially the organization of African American real estate brokers, and they do a broadcast, and I was privileged to do it recently. And the question, basically it's 5 brokers from all over Southern California were basically asking me questions, and I answered them. But the good news is they gave me a couple of questions in advance, and so I prepared them. And one of the questions had to do with risk. And so I spent a couple of days, and I thought I would share with you some of the statistics that I found. Concurrently, I was fortunate enough to serve on a committee that NAR has that does an annual legal scan. Some of you may actually be part of that committee as well. And so, number one in the area of risk right now is still our good friend disclosure. Okay? The difference is it isn't just the physical attributes of properties any longer. It's now the financial attributes of property that are getting brokers into trouble. And by far, number one are the different kinds of short sale misrepresentations that we're seeing. Number one, this is a national, not just California. Number two in terms of your risk is going to be dual agency. Not every state allows dual agency, but if you're representing both sides to the transaction, you have dual fiduciary responsibilities. And in a short sale situation, that can prove to be a difficult river to navigate. And so in terms of trends, that's another trend. RESPA, believe it or not. RESPA we used to only worry about periodically, but it's become a major area. In California, and in many of the states where foreclosures are high, liability relating to property management has spiked exponentially. And in fact, there's going to be a couple of seminars here. There's going to be one that's being put on, I think it's a CAR-sponsored seminar on property management. It's coming out fairly soon. You may want to take a look at that if you're doing property management. If you're doing REO properties, you're doing property management. And then I'm going to do one next month. That will be just inspiring. Interestingly enough, the next area of risk is in the area, I call it the going beyond your license risk. Practicing law, giving tax advice, telling people that the cracks in the driveway are not of a serious nature, those kinds of things. The next area, which is brand new, never seen it before, it's the mark of the beast, is social media. Okay? We're seeing people put listings on the MLS, or excuse me, they're not putting listings on the MLS, they're putting them on Facebook. They're not keeping them current. They're doing this. They're telling stories about other realtors on their own Facebook, like somehow, I'm not telling a lie. You've got to be understanding that just because it's on Facebook or Twitter. I got Twitter now. I found out. I didn't know that. I don't tweet, but I have people that do. And all that stuff is great. I love it. I absolutely think it's just the coolest thing. I mean, I got Dane over here that's keeping me current on all the young people stuff, and it's just phenomenal. But hovering around social media are the lawyers. Okay? And things like defamation of character, invasion of privacy, misrepresentation, unfair business practices. The only difference is now you get to do it instantaneously and with your iPhone. Okay? So again, those areas are starting to show a lot of exposure. And then I mentioned, of course, the safety concerns that we talked about earlier. In terms of offices, the primary reason that brokers and or the owners of offices get in trouble are because of the lack of proper written policies. Period. Okay? Office policies, the do's and the don'ts. One of the things, obviously, social media policy. You probably have an email policy. You need to have a social media policy. Training. Doesn't affect you guys. You're all here today listening to me blab on and on and on. The fact is that you need to do this all the time, every chance you get, because things are changing so rapidly. It's just ridiculous. And then in the area of broker supervision and monitoring, that's how brokers are getting in trouble. So, again, I'm not going to go into any more great detail. The cases are really, really interesting and not all bad. A couple of cases, I'm not going to go over the detail. There's a case that held that if you don't buy the title insurance, you're not entitled to sue the title company. Basically, you get nothing except information if you simply get a profile or preliminary reports or things like that. The exposure for liability does not affix to the title company until you actually purchase the contract. Okay? So just be aware of that. I told you about two cases the last time, and they seem to be really interesting in terms of how it's impacted banks. Up until not too long ago, basically anytime you entered into any agreement with a bank, it had to be in writing. Okay? Now we have two cases that say that may not necessarily be the case. In one case, the people didn't want to lose their home, and so they went to their bank. The banker said, look, what can you do? They said, well, we have another property. Somebody will lend us money to bring our loan current. Will you give us the time to put that together? He said, verbally, yes, he would. They went ahead and borrowed the money. They then completed the foreclosure before they could get the money in, and the court held those people could move forward with their lawsuit to set aside the foreclosure, even though there was nothing in writing. And I'm going to tell you why in a second. Then there was another case where the people had filed Chapter 13. For those of you that are familiar at all with bankruptcy, in Chapter 13, if you can establish that you can catch up the payments within 60 months and make the current payments and the other kinds of obligations, you can develop a plan just like you could in Chapter 11 if it's a big corporation. And these people did that. The bank persuaded them, well, we can't work with you unless you dismiss your bankruptcy. They dismissed the bankruptcy, they foreclosed, they lost the property, they filed suit, and they were able to move forward to go forward. So, why? Because there's a thing we learned in law school. It's a case that arose out of Ohio in the 1800s, where a woman accepted a job in Ohio from Pennsylvania as a nanny, so she took her family, moved to, and in those days, that was a pretty massive trek, as you can imagine. And they came up with this doctrine called promissory estoppel, okay? Which basically means if you make a promise verbally to somebody, and it's reasonable on its face, dismiss your bankruptcy, we'll work with you. Go get a hard money loan, we'll work with you. And there is foreseeable harm by breaching that promise, and the harm actually occurs because of the lack of the promise being kept, you may be able to bring an action for, it's called one of two things. You probably hear it either as, well, you aren't going to hear it at all because you guys don't go to law school, but it's either detrimental reliance or promissory estoppel. It's really the same thing. Okay? And it just simply means I reasonably relied on your promise to my detriment. You've caused me harm. You intended to do that, and I'm going to sue you. And in both Garcia and in Acevedos, that's exactly what happened. So be aware of that. That case I thought was huge because it changed the way, frankly, we're looking at some of these promises. And I've had these. I'm sure you guys have seen situations in your practice where the bank made verbal promises regarding loan modifications only to rescind them at a later time. In some cases, frankly, actually made written promises which they didn't keep. I don't know if it's happened to you. It certainly happened to me. There's those cases. There's a case basically that says if you dummy up a HUD-1 or lie on a HUD-1 or in any aspect, the title company, the escrow company, or the brokerage misrepresent anything on the HUD-1, there will be liability to the lender for whatever damages are created because the HUD-1 doesn't contain all the information. And what's the information? Things like money outside of escrow, stuff like that. There's a case called Bingo, where the broker did things beyond, well, the person did things beyond what a layperson could do, and the court held that they had to have a broker's license, and the language of that case clearly applies according to the Department of Real Estate to short sale negotiators. Okay? There's the Holmes case, which I'll talk about in a second. Some of you guys, I imagine because you have investors, you're doing home equity contracts where your investors are buying properties and then they're holding them, maybe flipping them, maybe renting them out for a while. If the property is in foreclosure, remember, you must use the notice of default purchase contract, which has the 5-day cooling off period in it. And what happened in one case, totally innocently, is the investor actually intended to originally live in the house for a while, and then he was going to fix it up while he lived in it. And then, it was basically one of these one-time, poor guy, thought he was going to get into flipping, probably saw something on television at 3 in the morning, and figured he'd get into the lucrative world of making millions in real estate on other people's money. Well, he did that. He moved into the property, but he took title in the name of his LLC. And the court held, well, is the buyer residing in the property? No, the buyer's not residing in the property. Therefore, it's a violation of the Home Equity Sales Act. They set aside the transaction and ordered all profit to be given to the original seller. So bottom line, you've got to understand that this is a really strict statute, and that case called Capone was decided a couple of months ago. Again, I told you before that statute, or that in California, the fact that a lender can't produce the original loan note isn't going to be dispositive so long as they can produce a reasonably accurate signed copy that everybody agrees is the copy of the original, because it's called the best evidence rule in California, and that's going to apply. Some of you that work in the commercial area, this is very important to me, but we use letters of intent a lot. Okay? And be careful about letters of intent, because there are lots of cases, the most recent one being decided not too long ago, that says that a letter of intent can be a binding contract. Because what does it take to have a binding contract? All of the essential terms of an agreement. Parties, price, terms, time, right? Well, if you can do that on a letter of intent, and it doesn't, and in this particular case, they use the deadly phrase, final proposal. Okay? Signed it. Now, the intent was to do a definitive agreement, but that's not what they did. And so the court held that the letter of intent was a specifically enforceable contract. So again, be careful how you use letters of intent, if you do use letters of intent. And then, of course, I'm going to talk about this case every time I come to see you. Holmes. I've talked about it 3 times now, so this is number 4. But again, what Holmes is probably the leading case of the year. When we first heard it, we went, of course, it's a stupid case, who cares? What happened in Holmes is, again, the listing agent didn't disclose that the property was a short sale, probably didn't even know it. This was at the beginning of the whole short sale cycle, and buyers purchased the property, sold their home, only to find out a few weeks before the close of escrow that they were $370,000 short of purchasing their dream home in Huntington Harbor. And they sued the listing agent, and the court held that you have a duty to disclose those financial issues that may prevent your seller from closing. Okay? Which is directly opposite of what we thought was the law, which is that you had a duty to maintain your client's confidential information. And so, again, I'm going to mention that case every time because we're still analyzing where it's coming from. The record will reflect that I am 5 minutes over my allotted time, and therefore I'm going to let you go. I will stick around for a few minutes, but I have a date with the lovely Connie to go over some of this fraud stuff, and so I've got to do that. But if there's any other questions, those of you that have to go, get the hell out. And we're going to do this again after the CAR convention, sometime in late October, early November. So we'll see you then. Thank you for coming on. Wait, James, you got something to say.
Thanks, John. I appreciate that. I just wanted to mention something that goes along great with the program today. The Valley Business Journal, Government Affairs Director Gene Weatherly does a fantastic